Well, hi everybody. Real Deal is back. Um, and today was the day that I promised everybody, or I informed everybody, that the Ethics Commission was holding a hearing for David Vigeant regarding the ethics complaint about the contracting with Gary Shepard on, yeah, for building the new water department building, which is depicted behind me. If you remember, or if you don't, I'll give you a brief update that Dave Vigeant and Gary Shepard were accused of violating the rules of ethics rules, because they had communicated about building this building and the awarding of the contract to Gary Shepard and his companies prior to the bids going out. And the Ethics Commission is accusing David of violating ethics by having those communications, and that Gary received unfair preference on doing the construction on this building. It's we're talking $4 million worth. Um, as I understand, there's no more. The complaint against Gary Shepard is non-existent at this time, because from what Gary allegedly spoke at one of the department head meetings a few weeks back, maybe even a month ago, and he told everybody that he paid his fine and moved on. He just, I guess, you admit to sufficient facts, or you pay an agreeable, you make an agreeable disposition, and you move on with your life. So for Gary, it's a cost of doing business. Unfortunately for Dave, um, and it's no cost to the town, by the way. It could be future. My concern is future cost to the town, but in this particular instance, it's Gary Shepard paid a fine. As far as I know, as far as what I'm heard secondhand, that he made these statements at a department head meeting. I don't know. Um, so it's very concerning. Anyway, um, yeah, I mean, it's upsetting. It's very upsetting. And when you watch what I'm going to show you, you might even be more upset than as upset or more upset than I am about what's happening here. But they're accused of violating what you're supposed to do in the bidding process, and it's quite costly. And just a preliminary information, today is it was I just got out of the meeting. It was at 2 o'clock today, 1400 for those of you on a 24-hour clock, and it was the meeting lasted about 30 minutes, or a little bit less, and it was just a pre-hearing conference in which my understand I'm not a lawyer, and sometimes I get the terminology a little bit wrong, but today was simply to put the parties together and make sure that all the administrative junk is taken care of, and that the lawyers, if you will, and the government and the what who's referred to as the respondent is Dave Vigeant, our water superintendent. There were some, I think, interrogatories, or 30, 30 charges or 30 questions that he needed to answer in order to get into the hearing mode. And what I'm going to show you um, on here is how this hearing went, or this conference went. Wasn't a hearing did not happen today, and all the dates are that are going to be upcoming are explained by the Ethics Commission representatives in this video. And I want to say something to Dave. I don't know if he watches my videos, but if anybody talks to Dave off duty, don't violate more ethics with Dave. But somebody, please get a lawyer. I mean, I do not know the context of what's going to be happening. Today didn't look good, but I want to just say I'm not a lawyer, but there's one piece of legal advice I will give anybody who needs it, and Dave needs it, and that's to get an actual attorney to do this stuff. Um, I'm really concerned that he's not in a position to properly defend himself, and he's representing himself, and this concerns me. I know lawyers ain't cheap, I've I've dealt with this issue. The lawyers are expensive, but the the end result here, the fine that Dave could get, the maximum fine is $10,000. And I want to remind everybody that when it comes to ethics violations and guilty findings and whatever, it's not on the town. The town won't be paying it, the water department won't be paying it. If he is found at fault here and he receives the maximum fine or any fine, it will be coming out of his pocket. He will be personally responsible for the fine. And it may have other conditions. I don't know what other conditions, I don't know. I've not watched one of these before. I've just read about some of them. But even, I haven't even, with this going on, I didn't even look at past cases. I just, every once in a while, you hear about other things that happen. I, yeah. But that's my big advice to Dave is to get an attorney, do a fundraiser or something, get a lawyer. You need one. Um, and you'll see the public. I know I'll get to it. I'm gonna start showing you the recording. I want you to. Geez, I mean, I don't know the things that are happening here, but I think that I just care that Dave has adequate representation, that he knows what he's getting himself into, and I really don't have a warm fuzzy here, and I don't know what the issue is. I don't know. I don't have an opinion of whether he's guilty or what have you, but it doesn't sound good. I don't even know the full charges. I know some of it that was posted, but he doesn't look prepared. And I know it appears that he thinks he is, but I don't think so. But all right, I'll shut up. I hear you people. You're saying, Cindy, shut up, get to the point. All right, let me show you the video. I'm gonna bring it up. Where are you? There it is. Here we go. Now we gotta find it again. Oh man. I know. It kind of starts, they didn't go on Zoom right away, so
today's date is July 28th, 2025, and it's 2 p.m. We're conducting this pre-hearing conference by video conference through Zoom webinar. Members of the public who wish to view this pre-hearing conference may do so by using the information posted on the Commission's calendar of events, and members of the public will not be visible on the video screen even if they are watching. Present with me is Mike McDonald, who is an attorney with the Commission's legal division, and he is serving as my legal advisor for this proceeding. Mr. McDonald has not been involved in any way in the investigation or prosecution of this matter. Also present with me remotely is Jerry Tuati, who is a member of the Commission's Public Education and Communications Division. Mr. Tuati is the technical assistant for this pre-hearing conference, and his camera's turned off, as you can see. I'd ask that the parties to this matter introduce themselves, beginning with Enforcement Counsel.
Good afternoon. My name is Candice Pruitt, and I represent the Petitioner State Ethics Commission.
Good afternoon. And Mr. Vigeant? I can't hear you, unfortunately, sir. We'll give you a moment. I'll give him another chance to see if he can figure out his audio issue. Mr. Vigeant, if you want, you can type in the chat what you're doing to resolve this issue. It looks like you're doing something.
Everybody who's watching, this is going to take a few more minutes for them to, or for Dave to figure out how to get his audio going. But the commission and the attorneys on here are being patient and giving him every opportunity, and they will. So nobody worry. He will figure it out. And then they will move on with this meeting. So we can be patient. I think it's helpful maybe to those watching that this difficulty is kind of representative of what we're doing, why I'm so concerned about Dave getting through this. But if you can hang in there, keep watching this. I don't have the opportunity, I don't believe, to speed this up. I'm not live here. I recorded it and then holding my camera. But I have software for this, but I haven't figured it out yet. I haven't taken the time to practice, so here we are. He's still trying to figure it out. He'll be back in a few minutes. Well, less than a few minutes. A minute or two.
Sometimes it's good to start again.
The attorneys are hopeful. They're smiling. Yes. Okay. So I can't express how serious this is for Dave. The man in the upper left-hand corner is an attorney, as is the woman on the bottom. They're both attorneys on this case. The state doesn't spare any expense when they're going through these complaints, and when they decide to bring charges, they've done a lot of homework. The law is sometimes, it is almost always, but when us lay people are dealing with the law and lawyers, sometimes we think we know what we're doing and we don't. And there's things that you just, I don't know. I mean, some people can do things pro se, i.e. pro se means on your own. And some things you're just not prepared for. And I think it's just my opinion. I'm not picking on Dave Vigeant. I feel bad for him right now because he's, to me, he seems very unprepared and for this important legal thing. Now, I don't know. I just don't know. And while we're waiting too, I don't want to put too much pressure on my opinion or my fear on this other thing that's part of this. Let's stick away from the camera a little bit. Is the repercussions of where this could go. I've said this in the other video that I did when I was first reporting this scandal, is that where the Ethics Commission appears to be believing, and Gary actually took the fine. All right, never mind. Keep going. We're back.
All right. Can you hear me?
Yes, we can hear you. Okay. So, Mr. Vigeant, why don't you just introduce yourself so that we have a clear record of you being on here and your audio working?
My name is David Vigeant.
David Vigeant. Okay. So, there may be delays in speaking at a hearing like this that's conducted via Zoom, so just be mindful of any of that. And obviously, sometimes there's technical issues that all of us encounter. So, and we appreciate that you've resolved those, Mr. Vigeant. If any party wishes to make a comment on a turn, just please raise your hand. Otherwise, I'm going to try to go back and forth between beginning with Enforcement Council and back to you, Mr. Vigeant. Okay, just for just keep it orderly. The pre-hearing order set out that the parties were to submit a joint statement or a separate statement by July 23rd. And I think I'm going to begin here with, I'm going to acknowledge that we received one from Enforcement Council, but Mr. Vigeant, we received something recently. I don't know if that's your answer or if it's your statement addressing the various issues in the case. Can you say one way or the other?
It's really both. I was trying to read how you wanted it. It said one, you have to acknowledge, and two, that you have to say whether you agree with something, and the third part was you got to give evidence. And so that's why they're numbered the way they are.
Okay. So, all right. So I think, well, before I move on to the enumerated list of items to address here at the pre-hearing conference, Attorney Pruitt, do you have anything you want to say with respect to the filing from the respondent? You're on mute. I'm sorry.
Am I unmuted now?
Yes.
Oh, good. Sorry about that. So yes, I did receive the respondent's filing. Unfortunately, it's not an answer because it doesn't address all of the paragraphs in the order to show cause, which there are 30 paragraphs. So I'm willing to give the respondent as much time as he needs to file an answer where he addresses all of the paragraphs in the order to show cause, but what he filed today was not an answer.
Okay. So I think what Attorney Pruitt is getting at is she has filed an order to show cause and has numbered paragraphs. The answer to that is supposed to have the same number of paragraphs effectively and respond to each paragraph one by one. If there are additional things you want to say, you may be able to say them in the answer as well. And so I think that's what she's getting at in terms of an additional opportunity for you to respond. Ordinarily, the response is supposed to have been filed already, but I recognize you're representing yourself and you're doing the best you can. And so, do you want another opportunity to respond as we've indicated?
I will respond, but a lot of them are going to be the same exact answer. Because
that's okay.
There's only 2 emails in question, and they were taken way out of context.
All right, but right. So respond paragraph by paragraph.
I will do that.
Okay, and I'm going to go through the 10 items that we need to talk about today. It may be that some of them either it's premature to address because the answer is not filed, or it's premature to address just because the parties haven't had an opportunity to confer with each other, or both. And so I'm going to go through them, but I anticipate that the answers may be, we're not ready for this yet. So why don't I go through? Attorney Pruitt, is there any possibility or any progress towards settlement if such conversations have happened?
make sure my audio is on. Yes, the respondent, Mr. Vigeant, has said that he doesn't want to settle.
Okay. And is that an accurate characterization from your perspective, sir?
Oh, absolutely. With the evidence I have done nothing wrong.
Okay. The scheduling order issued, I think about a month ago, and had various dates for discovery and for ultimately culminated in a hearing on September 16th. Are those dates now realistic or perhaps unrealistic? Attorney Pruitt?
I would say that those dates are unrealistic.
Okay. And Mr. Mr. Vigeant, I apologize. Do you understand what I'm talking about in terms of these dates relating to?
I do, sir.
Okay. And from your perspective, are these dates realistic or not realistic?
Not realistic. Right now, as of tomorrow, I have to do a back procedure. And I've been putting this off for about 2 years because I've been holding down doing this job and building a building. And I've been working 10 to 20 hours overtime a week to get this done. And it's been trying to say the least. And we're one of the first people to have a plan of this nature in the state.
Okay. So what, I'm putting you on the spot a little bit, but what would be a realistic time frame, maybe working back from a hearing date, an adjudicatory hearing date, and backing into the other dates to have this hearing? You said you're having a procedure. Are you going to be out of commission for a period of time?
The rest of the week, yes.
Okay. But
if you can give me the end of next week to answer for the 10 or the 20 items, would that be reasonable?
Yeah.
That would be the 8th of August.
Did you say the 8th? 8th of August? Yeah. Okay, sure. Yeah, the 8th of August to file an answer. That would be great. And then when would it be realistic? We can plug in the discovery dates in between, but when would it be realistic to have a hearing in this matter? Attorney Pruitt, what do you think?
I would say toward the end of September.
Okay. Does that sound reasonable to you, Mr. Vigeant?
Yeah, well, it gives another 2 weeks, right?
Yeah. Is that enough for you?
It's going to have to be because there's no more evidence I can get that I don't already have.
Okay, fair enough. So what would be a good date for everybody at the end of September? You want to like target the week of we could do it the 29th or the 30th, assuming the hearing room is available?
Yes, I'd say the 29th or the 30th.
Okay. Any preference, sir?
No, that's fine.
Any preference, Mr. McDonald?
No preference on my part.
All right, let's say the 30th. Okay.
30th?
Yeah. And then I think it might make sense, unless anybody has any preference for us, maybe Mr. McDonald could send out a revised order relating to discovery that also has new dates, has a new date for the respondent to answer. I wonder though, would it be useful to have another one of these conferences before the hearing? For whatever reason, it could be close in time to the hearing, but recognizing there may be, I want to make sure that the answer comes in and that it is an answer that is responsive. I have that in mind. I want to make sure that if Mr. Vigeant, if there's any discovery that that Attorney Pruitt has. I'm sure she'll give it to you, but if there's any question about that we have an opportunity to address before the hearing. If there's any issues relating to witnesses, there's an opportunity to address that. And if there's anything that would make the hearing go more smoothly by way of stipulations or agreed exhibits or anything that could be addressed ahead of the hearing, I'm happy to take the time to do that. Would that be helpful to everybody, Attorney Pruitt?
I think that would be helpful. I should also note that I plan to file a dispositive motion.
Okay.
And I mentioned in my proposed edits to the scheduling order that all dispositive motions be filed on or before 14 days after discovery responses are due.
That's fine with me.
So between now and whenever, and 14 days after discovery responses are due. But I do anticipate filing some sort of dispositive motion.
Okay. So I'm just looking at our current dates for when discovery responses are due. It appears that they're all due by August 6th. Is that right? Currently?
The requests are due August 6th. It looks, Oh, you're correct. Responses are due August 6th.
Okay.
Sorry about that.
Okay, so does it make sense to move that date out by 2 weeks as well? And so it may be all the dates that are on the order that exists now, maybe should be moved out 2 weeks to provide everybody the opportunity to file what they need to, including an answer that Mr. Vigeant intends to file, which I'm sure will impact what your motion for summary decision may say. And sir, do you understand what she means by filing a dispositive motion or?
I have no idea.
Okay, so it's a motion that ultimately, this is my phrasing, but is a motion that would resolve this case prior to a hearing based on whatever is argued in the motion, and you'd have an opportunity to respond to that motion if you disagreed with it, and so or even if you didn't, even if you disagreed in part and agreed in part. But you, anyway, have an opportunity to respond, including to oppose it. Okay, so, but it will be served by Attorney Pruitt would serve it on you, and I'd get a copy. You'd have an opportunity to respond, and the response time will be in this new scheduling order. And then I would read it. And would you anticipate asking for oral argument, Attorney Pruitt?
I do.
Okay, so we would have an opportunity to meet again, probably on Zoom, and to argue. So if this is hypothetical because I don't have it yet, but Attorney Pruitt would file the dispositive motion, would make an argument as to why she contends it has merit, and then you'd have an opportunity to respond in whatever way you want to that motion. But before you have to respond to it, you will have the benefit of receiving that dispositive motion from Attorney Pruitt and being able to write a response, or we would have a hearing and you can orally make the response. It's up to you, but that's what would happen.
Okay, that sounds pretty good.
Okay. Let me go back to my list of items. So I think we've dealt with the scheduling order. We've dealt with discovery. I think the other thing that you should file with your answer, sir, is a memo, kind of like Attorney Pruitt's memo that goes 1 through 10 and goes through the bulleted items that are in the notice of pre-hearing conference that came through before. So we've addressed things like schedule, but if you have disputed issues of law, any anticipated evidentiary issues, any witnesses that you'd like to identify, any difference of opinion you have as to the length of the hearing from Attorney Pruitt. She estimates that it'll be 1 day. If you thought it'd be shorter or longer, you should say so. Any agreed statement of fact or stipulations that you're able to come to. We know that we're going to have a dispositive motion from Attorney Pruitt, but you're also welcome to file a dispositive motion, sir. And anything else that might make this hearing go not faster, but more expeditiously, are things to flag. And I think it'd be useful if you did the same exercise and filed a memo, just going 1 through 10. If you have something to say it. If not, it's okay. But I think that would be a good exercise to do, and maybe when we have a hearing to argue any dispositive motion that comes in, maybe at the same time we can address any of these other issues. Does that give everybody enough time, or do you think that we should have a schedule, basically a second pre-hearing conference before having any argument on dispositive motions? Attorney Pruitt, I'm interested in what you have to say on that.
I don't think so. I mean, obviously, if Mr. Vigeant wants to have another pre-hearing conference, I will make myself available. But I think that the filing of the dispositive motion and his opposition will drive the timing of when we would meet again.
Okay. Mr. Vigeant, what do you think?
I agree with that. It's just gonna waste people's time, and I don't want to do that. I know you're busy, and there's a lot going on in the world.
Yeah, no, I just want to make sure, it's important that you have a fair hearing. I mean,
Right.
The hearings, it relates to your conduct or lack of conduct. I don't even know. But obviously you have an important interest in this hearing. I want to make sure that the adjudicatory hearing and everything we're doing is working towards that. And I want to make sure you have every opportunity to be informed, have a say, make any arguments you need to. And so I just want to provide those opportunities to you and to enforcement counsel as well.
Yeah, thank you, sir.
Sure. Okay. All right. So I think we'll send out a revised schedule, and we'll be looking for an answer by August 8th, as well as Mr. Vigeant's bulleted or numbered list 1 through 10, addressing the items in the pre-hearing scheduling order, and we can, any of those that require further conversation, we can address when we hold the hearing on the dispositive motion. Do you want to set a hearing date for the dispositive motion while we're here now, or do we want to wait until we get the motion, we get the response? What makes the most sense?
I'm sorry.
Go ahead.
I prefer the latter.
Okay, so
yes.
All right, so we'll wait. And Mr. Vigeant, what I'm getting at is I anticipate a dispositive motion from enforcement counsel. You can also file a dispositive motion too, or at the very least respond to her dispositive motion. But I think we're going to hold off unless you'd like to schedule anything now. I think we'd hold off on scheduling that until we actually get the filings. Is that okay with you?
That's okay, sir. Just so you know, I'm retired military, so I understand a lot of this.
No, I get it. I just want to make sure that everybody that you have a fair opportunity, like I said. So okay, then that's what we'll do. Mr. McDonald, anything else that we should hit on before we adjourn?
I think we've covered everything.
Okay. Thank you very much. I appreciate your time.
Thank you, sir.
Thank
Thank you,
you.
sir.
Thank you.
Thank you, counsel. Bye-bye.
Okay. Need to go back to the video if I can find it. It's here somewhere. Well, anyway, I don't know where it went. Oh, okay. Oh. Close that window. Okay, come back here. Sorry. So that was the entire conference, and you can, if you see it the way I see it, that Dave, I'm gonna say it again, Dave, get an attorney, please. I mean, I don't know how this is gonna end up, but it's not. I think you'd be better off with an attorney. And I want to say, I mean, towards the end there, I didn't want to interrupt most of this hearing. It was recorded. I could have stopped it and stuck my voice in there, and I chose not to. But right there towards the end, they were asking Dave if he understood things, and that there's a lot, and they were really supporting. I mean, the guy that was running this meeting, forgot his name. He was understanding, I think, of Dave representing himself and being kind. He was not being the least bit cruel. And he towards the end there, he asked Dave, everything, there's a lot here. Do you understand? And Dave responded by saying that he's retired military and he understands all this stuff. And it's like, he's told me a dozen times what he did in the military, but it wasn't legal work. I forgot what he did. Anyway, but I'm retired military, and I know how much trouble he's in, but I can't tell you. Being retired military has nothing to do with understanding all this legal mumbo jumbo, which is they're going very slowly. They're explaining in legal terms. They can't represent him. They can't explain. They can't give him any legal advice. And I'm certain that they're wanting. I mean, as human beings, they would love to. Dave, stop. They want to say you need a lawyer, but legally they can't. They can't give him any kind of advice like that. And so with that regard, I do feel really bad. And I think anybody who is watching my video is going to feel the same way, that, oh shit, what is going on? This is not good. And I just don't know what to say. There's going to be future conferences and hearings. I got to go back through this and check the dates in the video. I didn't write them down as we were going. I'll, as I can, I'll be following up and doing more videos with each of these meetings and the final hearing, if there is one. I wanted to express the attorney Pruitt, who was saying she's going to do a dispositive motion. That means she's going to ask for summary judgment again, basically. I mean, she could ask for dismissal. Oh, there's nothing here, but she would have said that already. They wouldn't be sitting here if she was going to just let the thing drop. But she's asking, basically, by saying I'm going to file a dispositive motion, is meaning, I looked up what that means, and you can Google that, and AI will give you a long answer, but basically asking for summary judgment, asking so that to not waste the time, and this is what Google tells you, not waste time, to waste the time of a trial. Let's just get to the meat of this. There's nothing here. Even no matter what Dave's going to present, well, they have to wait till Dave presents what he can, but he's apparently insists that whatever, there's nothing, which is upsetting to me. But she's already pretty certain. I think she seems very confident that she's going to be filing for summary judgment so that they can find him guilty without even going through a trial. And I don't know how that all works. See, I don't know the legalities of that, but because that can be like, how does it work if you're not a lawyer? I can't imagine that they will really have a clear understanding of what that means either. Even Googling it, well, I can read what Google says it is, but what does it mean in the process of this case? What can he expect? And what does he do about it when it's presented to him? And it won't be presented to him until he's sitting there in another hearing. Get him a lawyer. Jeez. I mean, a lawyer might save him and might even advise him, this is what it'll look like if you just just accept responsibility and move on, versus if you get found, I don't know if it's a guilty finding or find responsible. I'm not sure what the legal term will be in this type of a hearing, but I am very concerned. I don't know whether he's right or wrong in the ethics complaint itself. I don't know, because I haven't seen I've read what they proposed, and on that it sounds terrible, but I don't know. We don't know the details until we know the details. So, but just to think of him, I've spoken to him many times about water stuff, and he's very knowledgeable on water. I have faith that that building behind me is a good one. Oh, what I was saying, I cut myself off earlier. I said I was concerned that the other bidders, I'm concerned of a lawsuit against the town. It would be against the town on the bid. And I just hope we don't have that kind of lawsuit, because the other bidders could sue us because of the ethics concerns. And then we'd have to pay for the building all over again. But it would be either the town. It would be interesting. I think that would be an interesting case. I'm all over the map here. I'm not a lawyer, so I am making this up. But my questions would be out there. Is the town responsible? Because it was the fire chief who did this and then pled guilty, so to speak. It's a bidding process. So is it the water takers that are going to be out $4 million? Or is it the town? Everybody's going to need lawyers, so either way, we got to pay a lot of money. I don't know that our liability insurance would cover it. We shall see. If that happens, I don't know. I know I might be, my pessimistic side might be really out here in saying this stuff, but I'm gonna stop talking. I've got somewhere to be in a little while. So, and I want to get this up, and I'm going to put it on a premiere. Again, those are kind of fun. So, yeah, I'll leave it at that. You guys just regurgitate this video, because I think it's telling. All right. Well, thank you for watching. Again, I want to ask anybody who is not subscribed to please subscribe. You can share this with your friends, and put it on your Facebook groups, whatever. Share it on Twitter, X, Instagram. I don't know where you put these things, but feel free. I sometimes put it out on Facebook and a couple other places, but I think this is going to get circulated widely. And please like the video. That would be really nice. Even if you don't like it, just like it. Just please. It helps. I don't get paid. I'm not monetized, but it helps with viewership. It helps spread the good word. Spread the word on what's going on here on Real Deal News. So thank you for watching. Again, I really appreciate it. And thanks for your support. And I will catch you on the next video, what's tomorrow? Oh, there's a select board meeting tomorrow. That should be fun. I'll have to fill you in on what's going on. There's other things going on in town other than this. It's so much. They just don't know how to stop. And there are more ethics complaints coming down the pike. You probably heard about some of them. All right, I'll end. Goodbye. See you next time. Thanks for watching.